of Samuel Alito, in which Associate Justice Clarence Thomas joined. And I went and found the most liberal website I could, PBS. I know I'm bad. Here we go, folks. You can cite this case as 604. U.S. page number has yet to be assigned. That's generally the last thing that happens. And then it goes to the lawyer's edition. Supreme Court of the United States, number 24A1007. A.A.R.P. et al. Versus Donald J. Trump, President of the United States, et al. The et al. Means there's more than just the main defendant or the main plaintiff on application for injunction. So they just went right past the U.S. District Court, right past Court of Appeals, straight to the Supreme Court for an injunction. Ooh-wee. We should all have such privilege in the United States of America to be able to go directly to the United States Supreme Court and get instant relief. Do you see that? Do you see how that worked? Nobody else could get that to happen, but yet it happened. Justice Alito, with whom Justice Thomas joins, dissenting. Shortly after midnight yesterday, the court hastily and prematurely granted unprecedented emergency relief. Proceeding under the All Writs Act, Title 28 U.S.C., Section 1651, the court ordered the government not to remove a putative class of detainees until this court issues a superseding order. Although the order does not define the putative case or class, it appears that the court means all members of the class that the habeas petitioner sought to have certified, namely, all non-citizens in custody in the Northern District of Texas who were, are, or will be subject to the March 2025 presidential proclamation entitled Invocation of the Aliens Enemy Act regarding the invasion of the United States by Tren de Aragua and or its implementation. Motion for class certification in case number 125. And this is court number 125 is the year. CV is civil. CR would be criminal. And this is the 59th case to be filed in that court in the Northern District of Texas, Dallas, Fort Worth. And although the court does not specify what it means by the government, it appears that the term is intended to embrace all the named defendants, including the president. CF, compare Federal Rules of Civil Procedure 65D2. The court did all this even though, bullet point 1, it is not clear that the court has had jurisdiction. The All Writs Act does not provide an independent grant of jurisdiction. See 28 U.S.C. 1651A, permitting writs necessary or appropriate in the aid of a court's jurisdiction. Clinton versus Goldsmith, Supreme Court case from 99. The express terms of the All Writs Act confine the power of a court to issuing process in aid of its existing statutory jurisdiction, which means that, okay, the only way that they can use the All Writs Act is if they have already incurred jurisdiction. However, jurisdiction was not ripe in this particular, an emergency, emergency injunction. Application for preliminary injunction, temporary injunction, basically a TRO. Okay, so because they skipped the U.S. District Court and obviously skipped the U.S. Court of Appeals and went straight to the Supreme Court, the Supreme Court never had jurisdiction in the case. What happens when a court acts without jurisdiction? Everything's void and moot. Who's going to make that call? Who's going to hold the United States Supreme Court accountable? Here we go again with accountability, transparency, and truth. The act does not enlarge that jurisdiction, quoting section 1651A. Therefore, this court, the United States Supreme Court, had jurisdiction only if the Court of Appeals had jurisdiction of the applicant's appeal. See section 1254, granting this court's jurisdiction to review cases in the courts of appeals. And the courts of appeals had jurisdiction only if the supposed order that the applicants appealed amounted to denial of a preliminary injunction. You see what I'm saying? They just jumped way ahead, and the court bit. Took that hook and sinker, and C 1292A1, that would also be under Title 28 USC. But here, the order that the applicants appealed was what they viewed as the district court's constructive denial of their request for a temporary restraining order, a TRO. And I haven't read this either. Order, and that's why I can predict most of this before I even read it, because I know the legal machinations, how they're supposed to work. How they're supposed to work. And obviously, this is a they have a term for what this is. I'll get to it in a minute. That is, the district court did not actually deny their most recent request for a TRO, but they inferred that it was constructively denied because the district court failed to rule on that request before the expiration of a truncated counsel-imposed deadline. Okay, let's go back to that. Before the expiration of a truncated counsel-imposed deadline. That means the court didn't give a deadline. One of the counsels for the parties did. I don't know if that was the government or the ACLU. Maybe they'll get into it here later in this opinion or dissent. Okay, because the district court failed to rule on that request. Do you understand the term denied by operation of law? That occurs 120 days after any vehicle is filed into the court. If the court refuses to act upon the vehicle, whatever it is, whether it's a motion or writ, doesn't matter, it's denied by operation of law after 120 days. If we had the 120-day ripeness apply here, absolutely not. Are you seeing why people are so concerned about what the United States Supreme Court just did in this case? Do you completely comprehend now that it's really broken down by a legal analysis who's actually litigated in all these courts and knows what the fuck is going on and what's supposed to happen? Because you're not going to hear this on Fox. You're not going to hear this on, definitely not on CNN and MSNBC. The denial of a true TRO is not appealable. Okay. And here, it is not clear that the applicant's TRO request was actually denied, and it wasn't. You see what I'm saying? It's like everybody, you know, all the players are on the field, but we're not really playing. But the other team's going to go ahead and run their play and score a touchdown, and the officials are not. You know, oh, touchdown! That's what just happened. Okay, and the refs, that's the Supreme Court. The team that threw the ball scored a touchdown. That was the ACLU. The government, they were just standing around going, nothing to see here. All right. Indeed, in an order issued last night, the Fifth Circuit U.S. Court of Appeals in New Orleans, Louisiana, over Mississippi, Louisiana, Texas, held that it lacked jurisdiction for this reason. See id at 1. And that would be talking about this case right here. See order. And let's scroll down. Bullet point number 2. Okay? Because we're going to have some real problems here.
Wrong day.
Because generally, get an eyeball on you guys. Generally, the Supreme Court will take up a case when there are what's termed as split circuits. What's a split circuit, Floyd? A split circuit is when I have the U.S. Court of Appeals, Fifth Circuit in New Orleans. They rule this way. I have the Ninth Circuit Court of Appeals in San Francisco, California. They're very liberal. They're the other way. Okay. So I have two differing opinions that go against each other. One from the Ninth U.S. Circuit Court of Appeals and the Fifth Circuit U.S. Court of Appeals. I need a tiebreaker. So where do we go? The United States Supreme Court to determine whether or not who holds precedent, the Ninth or the Fifth. That's generally what the Supreme Court does. However, there are other vehicles that are filed in there, like writs of habeas corpus, writs of mandamus, other extraordinary legal vehicles. But for the most part, the machinations, the generalities of what's filed in the United States Supreme Court is either appeals that are going up the chain, or there's a split circuit that needs to be remedied and ratified by the court, because we need the law of the land. We need uniformity, right? So that's what we're looking at there. Let's get back to the case. Bullet point number 2. It is questionable whether the applicants complied with the general obligation to seek emergency injunctive relief in the district court before asking for such relief from an appellate court. And not only do they just ask it from an appellate court, they went to the highest appellate court you could go to. They like skip the line, folks. You know, what do we think about people who cut in front of us and skip the line? Exactly. When the applicants requested such relief in the district court, they insisted on a ruling within 45 minutes on Good Friday afternoon. When the district court did not act within 133 fucking minutes, they filed a notice of appeal, which the district court held deprived it of jurisdiction. It is doubtful that this aborted effort satisfied Federal Rules of Appellate Procedure 8A1C. Okay, folks, this is what the ACLU did. They ran into court, filed a temporary restraining order application, and they wanted a ruling in 45 minutes. They told the court, you're going to have a hearing and you're going to rule on our filing in 45 fucking minutes. Have you ever heard of that happening? This is what 7 justices on the United States Supreme Court just did. They just bent every United States citizen, United States national over a barrel, and they just went to town on us. Absolutely. Can y'all spell treason? Because that's what they're doing. This is treason. This is treason, folks, in my opinion. It is, okay, we're going to go bullet point number 3. When this court rushed to enter its order, the Court of Appeals was considering the issue of emergency relief, and we were informed that a decision would be forthcoming. This court, however, refused to wait. But under this court's rule 23.3, which I'm quoting, except in the most extraordinary circumstances, an application for a stay will not be entertained unless the relief requested was first sought in the appropriate court or courts below or from a judge or judges thereof. So basically, what he's saying is that the United States Supreme Court was aware that a court of appeals had received the appellate notice on Friday from the ACLU that when the court didn't rule on their TRO within 45 minutes, and they didn't act within 133 minutes, which is a little over 2 hours, they filed their notice of appeal. So the U.S. Court of Appeals, I don't know which district yet, got a hold of it, and they were going to consider it. And it was Good Friday, folks. It was Easter weekend. And I don't know about you, but everybody took Easter off on Wednesday. I mean, I was trying to get people to do something. I was like, it's Easter. Yeah, Sunday. Okay. If you want to do a week Easter, knock yourself out, man. More power to you. But this is the okie doke bullshit that they pulled. Okay. Good Friday, a holiday, going into Easter weekend. And then, of course, it's Easter Monday, and, everybody's half-assing it again. So let's continue. Even though the Court of Appeals held it, the Supreme Court knew it. Justice John Roberts allowed it. Jesus Christ, I hope there's a picture of him on Epstein Island. I hope he's on the flight logs repeatedly, in my opinion. Next bullet point. The only papers before this court were those submitted by the applicants. The court had not ordered or received a response by the government regarding either the applicant's factual allegations or any of the legal issues presented by the application. And the court did not have the benefit of a government response filed in any of the lower courts either. When the applicants first raised their allegations in the district court, that court provided the government with 24 hours to respond and was poised to rule expeditiously. But the district court dissolved the government's obligation to respond after counsel for applicants filed their hasty appeal, which, in the district court's view, deprived it of jurisdiction to rule. Are you seeing all the legal hanky-panky going on here? The reach arounds, pull downs, zipper up your back. Next bullet point. The papers before us, while alleging that the applicants were in imminent danger of removal, provided little concrete support for that allegation. Members of this court have repeatedly insisted that an all writs act injunction pending appeal may only be granted when, among other things, the legal rights at issue are indisputably clear, and even then sparingly and only in the most critical and exigent circumstances. You see all the adjectives they're using in there? because they're trying to make a point. I'm not going to do all the citings. Next bullet point. Although this court did not hear directly from the government regarding any planned deportations under the Aliens Enemy Act in this matter, an attorney representing the government in a different matter, JGG versus Trump, informed the district court in that case during a hearing yesterday evening that no such deportations were then planned to occur either yesterday, April 18th, or today, April 19th. Did I mention there's some legal hanky-panky going on here? Somebody getting a reach around, and it ain't me, and it ain't you. Although the court provided class-wide relief on an injunction, that there's no precedent for that either. The district court never certified a class, and this court has never held that class relief may be sought in a habeas proceeding. The court just wrote new law. Okay? Because now that's precedent. That's going in the books. Absolutely. So if you know anything about West's key code, that's going to be under there. This is now law of the land. They just amended the All Writs Act. This is called legislating from the bench, folks. That's what the Supreme Court just did. Here's the pushback. In sum, literally, in the middle of the night, the court issued unprecedented and legally questionable relief without giving the lower courts a chance to rule, without hearing from the opposing party. Sounds like some little due process violations. Within 8 hours of receiving the application. With dubious factual support for its order and without providing any explanation for its order. I refused to join the court's order because we had no good reason to think that, under the circumstances, issuing an order at midnight was necessary or appropriate. Both the executive and the judiciary have an obligation to follow the law. The executive must proceed under the terms of our order in Trump versus JGG, and this court should follow established procedures. Mic drop. Thank you, Samuel Alito, for that dissent. I was glad I could be the one to break this actual down, word for word, phrase for phrase, law for law, exactly what has happened